Right now, if a police officer wants to read every letter you mailed last year, they need a warrant, they need a judge, they need probable cause. That process has not changed in over 100 years. If that same officer wants to read every email you sent last year, in most of the United States, they do not need a warrant. They need a subpoena. A prosecutor signs it. No judge reviews it. Google hands over your inbox. Done. That is not hypothetical. That is current law. And the gap between the protection on a sealed letter and the protection on an email is one of the biggest legal blind spots in the country right now. Federal agencies have exploited it for decades. Courts are split on whether it is even constitutional. Congress has been trying to fix it for over 10 years and has not. By the end of this video, you will either know exactly what protection your email actually has and how to think about what you put in it, or you will keep treating your inbox like it is sealed when it is not. I am Ben. The Fourth Amendment protects you from unreasonable searches and seizures. For physical mail, that protection is clear. A sealed letter in transit has strong constitutional protection. Courts have upheld it consistently. Police need a warrant signed by a judge who found probable cause. That standard is not negotiable. Email is governed by a completely different law. It is called the Electronic Communications Privacy Act. It was passed in 1986. That is the year before Microsoft released the first version of Windows. The people who wrote that law were imagining a world where most Americans had never sent an email. And the law reflects that. Under the original text of that law, emails older than 180 days were classified as abandoned, legally abandoned, like a piece of furniture left on a curb. Once your email sat on a server for 6 months, the government could retrieve it with a subpoena, not a warrant. A subpoena means a prosecutor signs the paperwork. No judge has to agree. No probable cause standard applies. The company gets the request, and in the majority of cases, they comply. For emails less than 180 days old, the law did require a warrant. But for anything older than that, the standard dropped entirely. The legal protection on your email came with an expiration date written directly into federal law. In 2010, a federal appeals court in Ohio challenged that framework directly. The case was United States versus Warshak. Stephen Warshak ran a company that sold supplements. The government was investigating him for fraud. Prosecutors used the 180-day subpoena provision to obtain roughly 27,000 of his emails from his internet service provider without ever going to a judge. The Sixth Circuit Court of Appeals ruled that violated the Fourth Amendment. People have a reasonable expectation of privacy in their email content. The 180-day abandonment rule was unconstitutional. A warrant was required. That ruling mattered. It was a genuine legal victory for privacy. And it applies in 4 states: Ohio, Michigan, Kentucky, and Tennessee. If you live anywhere else in the country, that ruling does not automatically protect you. The 1986 law, with its 180-day rule and its subpoena standard, is still the operative framework for most of the country. There is a second problem that goes even deeper than the 180-day rule. It is called the Third-Party Doctrine. When you send an email through Gmail, you are giving that email to Google. Google stores it, processes it, reads metadata from it, and holds it on their servers. Under the Third-Party Doctrine, when you voluntarily share information with another party, you lose your Fourth Amendment protection in that information. The Supreme Court established this principle in the 1970s in cases involving bank records and phone numbers dialed. Courts applied the same reasoning to email providers. The Department of Justice stated its position explicitly in federal court in 2013. Americans have no reasonable expectation of privacy in email content stored by a third-party provider. That was not a fringe argument. That was the government's official position, stated openly, in court. Google publishes transparency reports. In recent years, the company has disclosed receiving tens of thousands of data requests from U.S. law enforcement and government agencies annually. Microsoft receives comparable numbers. In the majority of cases, the companies comply. Your email provider is not your attorney. It does not have attorney-client privilege. When the government asks, most providers hand over what they legally must, and sometimes more. In 2018, the Supreme Court decided Carpenter v. United States. That case involved cell phone location data. The FBI had obtained months of location records without a warrant, using the same stored communications framework that governs email. The court ruled that accessing 7 or more days of cell site location data requires a warrant. Chief Justice Roberts wrote that the third-party doctrine has limits. That some kinds of comprehensive digital records are different from a bank statement. That was real progress. But Roberts was explicit that the court was not overturning the third-party doctrine broadly and was not addressing email. The ruling was narrow by design. The question of whether your email content gets the same protection as your location history has not been resolved by the Supreme Court. Lower courts are split. Federal agencies that have accessed email content without warrants include the IRS, the SEC, the EPA, and the FBI. The IRS maintained an internal policy until 2013 stating it did not need a warrant to read Americans' emails. It reversed that policy under public pressure. The reversal was a choice, not a legal requirement. The day before that policy changed, the legal argument for warrantless email access existed. The law that would have stopped it did not. The NSA's PRISM program, revealed in 2013, collected email content directly from Microsoft, Google, Yahoo, Facebook, and Apple. Yahoo challenged the program in a secret surveillance court. It lost. The government argued that foreign intelligence collection did not require individual warrants for email content. The court agreed. Here is what you need to understand. A sealed letter sent through the postal system has over a century of consistent constitutional protection behind it. Courts have never wavered on that. A warrant is required. Full stop. Your email has a 1986 law, a 180-day abandonment rule that one circuit court has struck down and others have not. A third-party doctrine that strips away protection the moment Google stores your message, and a Supreme Court that has signaled concern about digital privacy without yet resolving the email question directly. The practical difference between writing a letter and writing an email is this. One of them lives behind a legal wall that has never fallen. The other lives in a legal gray zone that federal agencies have quietly exploited for decades, that Congress has failed to close, and that most people using email every day have never thought about for a single second. Treat your email accordingly. Understand what you are actually writing and where it is actually stored. If you are involved in anything where legal exposure is possible, talk to an attorney before you assume the same rules apply to your inbox as to your mailbox. They do not. I am Ben. Subscribe. New video every day. I will see you tomorrow.